5 seconds to go. Start. In the present case, we are of the considered opinion that the defense raised by the appellant satisfies the standard of preponderance of probability. Stop para. Insofar as the reliance on the judgment of this court in the case of Rohit Bhai Jeevan Lal Patel versus State of Gujarat and another supra is concerned, in the said case, the learned trial court had acquitted the accused, the High Court, in appeal, reversed the acquittal and convicted the accused for the offence punishable under section 138 of the NI Act. Stop. Affirming the order of the High Court, this court held that merely by denial or merely by creation of doubt, the accused cannot be said to have rebutted the presumption as envisaged under section 139 of the NI Act. Stop. This court held that unless cogent evidence was laid on behalf of the accused in defense of his case, the presumption under section 139 of the NI Act would not be rebutted. Stop. As such, the said judgment also would not be applicable to the facts of the present case. Stop. Para. In that view of the matter, we are further of the considered view that the High Court was not justified in reversing the order of acquittal of the appellant. Stop. Para. That leaves us to consider the civil appeals. Stop. Insofar as the civil appeals are concerned, the High Court, by two different judgments and orders, has reversed the judgments and orders of the learned trial court, dismissing the suits, thereby decreeing them. Stop. It is a settled proposition of law that the standard of proof in criminal proceedings differs with that in civil proceedings. Stop. Para. A distinguishing fact between the criminal proceedings and the civil proceedings in the present case is that, while in the criminal proceedings the complainant had failed to produce the promissory notes, in the civil proceedings, the complainant had proved the promissory notes. Stop. The High Court found that the civil appeals were required to be decided on the basis of the preponderance of probabilities. Stop. The High Court found that the complainant had established that he was working as a LIC agent, that his father was owning extensive agricultural properties and that he was deriving agricultural income. Stop. The High Court, on the basis of the evidence placed on record, relying on the preponderance of probability, came to a conclusion that the plaintiff had the financial ability to lend the sum of rupees 3 lakh as on 20th October 1998. Stop. The High Court also found that the appellant's wife was not examined as a witness in the said case so as to probabilize the defense plea. Stop. The High Court found that the best available evidence was withheld by the defendant's appellants herein, and as such, the principle of adverse inference was also applicable. Stop. Para. Though it was so to be argued before the High Court that in view of the judgment in the criminal proceedings, the suit was also liable to be dismissed, the High Court rightly observed that the adjudication in civil matters is based on preponderance of probabilities, whereas adjudication in criminal cases is based on the principle that the accused is presumed to be innocent and the guilt of the accused should be proved to the hilt and the proof should be beyond all reasonable doubt. Stop. Para. We therefore, find no reason to interfere with the judgments and orders passed by the High Court in the civil appeals. Stop. However, in the facts and circumstances of the case, we are inclined to modify the decree. Stop. During the pendency of the proceedings before this court, the appellants have deposited an amount of rupees 7 lakh and rupees 2 lakh pursuant to the orders of this court dated 20th February, 2009, passed in criminal appeal number 1978 of 2013, arising out of special leave petition criminal number 1456 of 2009 and connected matter and dated 13th August 2012, passed in civil appeal number 10501 of 2013, arising out of special leave petition civil number 23036 of 2012. Stop.